joint statement by the candidates for the Uganda Law Society representatives to the Judicial Service Commission. And I'll straight read the statement. Joint statement by candidates for the ULS representative to the Judicial Service Commission. We, the undersigned candidates for the position of the Uganda Law Society nominee to the Judicial Service Commission, speak with one voice in defense of the independence of the legal profession and the rule of law in Uganda. The events unfolding before us reveal a deliberate and dangerous attempt to undermine the autonomy of the ULS and erode its statutory mandate. Let us be clear, we will not stand by as this assault on our professional integrity and democratic rights takes root. The consolidated ruling by the High Court in the miscellaneous application number 1243 of 2024, Mugisha Hashim Mugisha versus Uganda Law Society and 8 others, and miscellaneous application number 1262 of 2024, Fiona Navasa Gladys Wall versus Uganda Law Society and another, raises grave concerns regarding the potential to erode the autonomy of the ULS and its constitutional duties. In light of these developments, we deem it imperative to take the principled actions to A. Categorically reject any effort to reduce the ULS to a mere pawn in the hands of external interests. Use all lawful means to challenge any affronts to the independence of the ULS. Call upon all members of the legal fraternity on the bench, at the bar, and in academia. This is the time to rise, unite, and safeguard the independence of the ULS. Support the leadership of the ULS and to stand with it in its pursuit of every legal institution and administrative avenues available to protect the independence of the ULS. The public should recognize that the fight against the erosion of the independence of the ULS independence is not just a lawyer's fight. The erosion strikes at the core of justice and accountability for every Ugandan. This is not the time for silence, hesitation, or compromise. The legal fraternity and the public must stand together to defend the values that define our profession: independence, integrity, and the rule of law. We are resolved. We are unshaken. We will fight together. We will assure that the Uganda Law Society remains a beacon of justice, accountability, and fearlessness in Uganda. That is the statements of all the 14 candidates campaigning to be nominated to join the Judicial Service Commission. Thank you.
Yes, what I think needs to be clarified is that we do not think Uganda Law Society is at loggerheads with the judiciary. It's simply that there are some judicial officers who are trying to gag Uganda Law Society. This is judicial overreach. The orders which were granted by the High Court are judicial overreach. Courts of law can grant injunctions where they are warranted. But you need to consider that what is happening here is that the injunction given is basically making it impossible for Uganda Law Society to elect leaders to pursue a mandate that benefits the public good as well as the membership. And therefore, this is judicial overreach. It's not a usual situation. And we strongly doubt that the majority of judicial officers in the judiciary would actually endorse the ruling that was made on Friday. Yes, when we talk about lawful means with which we shall engage, we are referring to both within the courts of law and outside the courts of law. Because what happens is that when you are not happy with a court decision, you can appeal it to another court, but you can also sensitize the public to understand what a travesty that decision is, so that the public can know. Judicial officers are also subject to accountability. The exercise which has been stopped by the High Court was in fact for choosing two representatives who will be then considered by the President for appointment to the Judicial Service Commission. The Judicial Service Commission is the body that appoints and disciplines and regulates all judicial officers, from judges and justices of the Supreme Court, Court of Appeal, High Court, and magistrates. And that body also has members of the public. There are two, actually, the Judicial Service Commission has two members whose job is to represent the public interest. And therefore, we are trying to sensitize even members of the public to know that it's important to have elections of the Bar Association to choose our representatives who make input on the appointment of judges and justices. And therefore, the lawful means for challenging this order, which we consider obnoxious and the travesty of justice, will include may include appellate options, may include administrative measures, as well as sensitizing the public. All that we emphasize, because we at the Uganda Law Society, we operate within the ambit of the law, but the options we have on the table are not only going to be limited to challenging these orders in the courts of law. I think first of all, we thank all the members of the bar who have already been supporting this process. As you can see today, we have here in this room over eight candidates who have sat together in a bipartisan manner to sign off a joint statement. That's the kind of support we mean from all the lawyers, because the process which is going on, the legal process, the injunctions which have been granted by the court, are really an attack on the legal profession in Uganda. They are not simply an attack on law society, and maybe it is important to emphasize that this is not the first injunction, it's not the first time. We had an injunction issued by the same court in February this year. For sure, we didn't have the current leadership of the law society, and therefore nobody should be deceived that because of the elected leadership we have, somehow now the judiciary is at loggerheads with the law society. No. The only thing that has changed is that we simply have a leadership that is determined to be assertive and ensure that further erosion of the right and independence of the bar comes to a halt. There's a number of things. One, it requires that judicial decisions must be delivered in accordance with the law. And our complaint now is that we have decisions gagging Uganda Law Society, they are not delivered in accordance with the law. Some of our individual members are going to the courts of law and getting orders against the Bar Association, which orders clearly are not grounded in the law. And therefore we have to object to them. We will challenge them legally, but we shall also make it clear to the public so that everyone appreciates what's going on, because a gagged law society is very dangerous for the society, for the whole country. Law society does a lot of work. And if it becomes impossible for law society to carry on its legitimate and lawful activities, then it's bad for the public good. What has actually been happening, and that is why you see that we are very concerned. To take an example, when the Honorable Justice Judge Ssekaana issued an injunction in the case of Brian Chilima versus Uganda Law Society, the injunction stopped members of law society from requisitioning for meetings to conduct extraordinary general meetings pending disposal of that case. As we speak, that case has never been disposed of. It's 10 months later. 10 months later, members of Uganda Law Society cannot requisition for extraordinary general meetings in light of that injunction. And so when we say that these injunctions are simply designed to gag the law society and frustrate its ability to conduct its legitimate and lawful activities, we are not exaggerating. It's what it is. We have got a framework under the law that governs the operations of Uganda Law Society. The Uganda Law Society Act, Chapter 305, Laws of Uganda, provides a right to members to requisition with only 15 signatures to requisition for an extraordinary general meeting. Uganda Law Society right now has a membership that's over 5,000 members. But because we are following a law that was enacted several years ago, in 1956, it requires a member who is aggrieved. Any member who thinks the leadership has gone astray, who thinks the leadership is misbehaving, who thinks the leadership is departing from the mission of Law Society, has a right to requisition for an extraordinary general meeting. And all that such a member needs are 15 signatures of other 15 willing members to cause such a meeting, to address those concerns, and pass resolutions. And therefore, when a member rushes to go to a court of law, we expect that the court will take into account the provisions of the Uganda Law Society Act. The law requires that before you go to any court of law, you should first exhaust the internal administrative remedies. When that has not been done, and then a court of law issues an order stopping an organization with 5,000 members from carrying out any meetings because one member is aggrieved, it's simply a travesty. It's an affront to democratic rights of members. You can't have one individual stopping 4,999 members from meeting and discussing their affairs. Courts of law are required to apply the law. And what our biggest concern at the moment is that these cases involving Uganda Law Society are not being determined in accordance with the law. And orders are being given, then the courts of law are delaying determination of the substantive disputes, and therefore that renders it impossible for Uganda Law Society to carry on its lawful mandate. Like the candidates have indicated in their statement, there are several options on the table in dealing with the delay. If the High Court chooses to delay and not deliver a decision in a timely manner so as to continue gagging the Law Society from conducting its elections, from members debating these issues, there are options that will continue to be considered. And obviously, we have an elected leadership. It will continue to give guidance on the options that we shall pursue as members. I think the challenge that we will have, if we do not have an election, it will mean that you shall have, under Article 146 of the Constitution, the Judicial Service Commission must be composed of various representatives of various organs, including Uganda Law Society. Therefore, if we do not have this election, and the term of office expires, which it's doing this month, of the two members currently representing Uganda Law Society, we are going to be in a constitutional vacuum, in which case it will be unlawful for Judicial Service Commission to continue operating, processing appointments of judges and magistrates when it is not lawfully constituted. We are right now facing attacks and criticisms from some of our members who claim that our leadership is not lawfully constituted. But some of them are the same people who don't want us to ensure we have a lawfully constituted Judicial Service Commission. The Judicial Service Commission must be lawfully constituted as per Article 146 of the Constitution. And if that does not happen, it's going to be our view that all the appointments that will be made, all the actions made by the Judicial Service Commission in that state will be unconstitutional.
The candidates are now going to append their signatures in their own statement.